Good morning. Bernice Eugene, attorney for Raich. This is a very simple case. My client is very ill and has been prescribed by her doctor the use of marijuana for medical purposes. The DEA has overstepped the Compassionate Act of 1996, which legalized the use of marijuana for medical purposes in the state of California. The DEA entered my client's home and destroyed her marijuana plants, which again was prescribed by her doctor because she is very ill. The DEA justified her actions with the U.S. Attorney's backup, claiming that the Compassionate Act of 1996 interfered with the Federal Substances Act, which banned the use of marijuana for any purposes. This is the reason why we're here today, because we have to ask ourselves, is the basis of this law correct? Because Congress passed this law under the Article 1, Section 8, which states that Congress has the power to regulate interstate commerce. Now, when we look at it, marijuana and medical use of marijuana does not relate to interstate commerce. The prohibition of marijuana use for medical purposes on the basis of power to regulate interstate commerce is not narrowly tailored. There's no need to create a law if it's not going to relate to the Constitution's delegation of power that Congress has. We've seen how this court ruled on cases like this before. U.S. versus Lopez. The court said that the possession of a gun in a local school was not an economic activity, although it is a criminal law. It cannot be passed on the basis of trying to regulate interstate commerce because it does not relate, is not a part of those class activities. In U.S. versus Morrison, we see the same thing when the court decided that the Violence Against Women Act of 1994 could not be enacted on Congress's power to regulate interstate commerce because it's not a part of those class activities. It does not relate. There's no relation between the two. This is relevant to my case because we're seeing the same thing with marijuana. My client growing marijuana in their backyard does not really affect interstate commerce at all. So we asked that the court, consider the 10th Amendment when deciding this case also, because the 10th Amendment states that whatever power is not delegated to Congress by the Constitution will be left to the state and the people. We've seen that Congress' choice to ban medical marijuana use cannot be on the basis of interstate commerce because it does not relate, and it wouldn't be narrowly tailored. The Constitution does not speak on the medical use of marijuana. So we ask that the court just let the people and the state of California decide their fate. Thank you.